Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Aman Gebru, Visiting Assistant Professor of Law at Yeshiva University Benjamin N. Cardozo School of Law. We will discuss his article, Patents, Disclosure, and Biopiracy, which will be published in the Denver Law Review. So welcome to the show, Aman.
Thank you for having me, Brian.
So I really enjoyed reading your paper, especially because I've been trying to read more about patent law and about traditional knowledge recently. And I had, as you, I think, recall, Jan Osai Tutu on the program a little while ago, engaging with some similar ideas, but in a different way. So I was wondering if you could start the interview by explaining to listeners what traditional knowledge is and why it's important.
Sure. And I, as I mentioned earlier, I listen to your podcast quite often, and listening to Janawa's kind of talk was really interesting, and in different ways it connects with mine. So traditional knowledge, I define it very narrowly compared to other people in my field. And I define it as the know-how, the skills, the innovations and practices of indigenous people and local communities. So this is a narrower definition, and the contrast would be a much broader definition, which would include what I just defined as traditional knowledge, but also sorts of cultural expressions, artifacts, things that you would not necessarily associate with knowledge, quote unquote, as in knowledge, know-how, or tacit knowledge, if you will, but some sorts of expression, cultural expressions, physical things such as artifacts. So some scholars in my area of research do include all of these things to be traditional knowledge. But I choose this narrower definition because I think it lends itself to a more in-depth analysis of what we're thinking of when we say traditional knowledge. And it does relate to the extent that you want to look at intellectual property issues. It relates more to subject matters that would be protected under patent law, as opposed to, say, copyrights or trademarks, in that it's looking at know-how as the subject matter.
So why is traditional knowledge important in a patent context? In other words, how does it get used by people who are engaging with the patent system, and what kind of resources, traditional knowledge resources, are available? In other words, what kind of information are people using it, and how are they using it?
Yes. So there are multiple types of traditional knowledge. So if we're zooming into that term itself, we find different groupings. So traditional agricultural knowledge, traditional ecological knowledge, traditional environmental knowledge. So you can divide it into its subparts. But to give you an example of what types of knowledge I'm talking about is, the best example I can think of is when, say, a pharmaceutical researcher, learns about the traditional practice that a certain community has of using certain parts, roots or leaves of a plant to treat a disease. And so that traditional knowledge of using certain parts of the tree, how to extract, say, oil, how to apply it to the body, and the like, all of that would be traditional knowledge. And the typical example would be that the pharmaceutical researcher learns of this traditional practice, tries to extract the active ingredient from the plant, and then develops it into a patentable drug that's hopefully ultimately approved by the FDA, the Food and Drug Administration. And so that's how it is relevant for patent discussions, where patent law does protect the innovation that arises from any different fields. But if the inventor, so to say, has used traditional knowledge at the beginning of that process and either develops it into a patentable invention that meets the novelty and non-obviousness requirements, the question then is, currently patent law rewards the person at the end of that innovation process. But what do we say about the inputs that people provide earlier in that process, right? So what do the communities say about whether they have a right or some sort of claim, not even a right in terms of legal right, but do they have any sorts of claim in the earlier knowledge of that, quote unquote, invented knowledge or protected knowledge at the end of that spectrum?
So why do inventors rely on traditional knowledge? Does it help them innovate more efficiently?
Yes. So there are, a few empirical research projects that have been done on this topic, and a lot of them come out of the pharmaceutical industry area, but there are others in, say, environmental conservation, agricultural practices, and the like. But sticking to the pharmaceutical example, a number of research projects starting from the 1990s show that researchers have two alternative ways of developing drugs or treatments in general. One is to kind of use the common. I don't know if I should call it common, but one option is where you take, for example, thousands of plant samples, run them through high-functioning machines, and you just hope to get a hit. A hit meaning a plant that has interesting chemical features to it, active ingredients that you can use. The other option is kind of a shortcut of saying, there are communities out there in the world that have used plants and animals and other kind of minerals as input in addressing a lot of health issues that they have. And so instead of just in abstract, blindly screening samples, let's learn from these communities that have used this for centuries and kind of use it as a shortcut. So the empirical research shows that significant improvements are achieved if you use traditional knowledge. So your chances of getting an active ingredient from a plant increases a lot if you use traditional knowledge. So in one project, for example, this is from the 1991, I believe, a paper looked at a certain sample and said your chances of getting a preliminary hit, which is the first kind of interesting sample that you get from the thousands of sample. So your chances of getting a preliminary hit increased from 6% without the use of traditional knowledge to 25% with the use of traditional knowledge. And so it's that increase, I think, that researchers are relying on when they use traditional knowledge. And because of the value of traditional knowledge, you see all sorts of journals. So the Journal of Ethnopharmacology is one of the more famous ones that's dedicated to this type of research, which is using traditional knowledge to develop interesting modern drugs and treatments.
So you give several different examples of how inventors have used traditional knowledge in your paper. I thought the neem tree extract one was particularly interesting. Mm-hmm. Could you kind of share the background behind that? And maybe we can use that as an example to think about the proposals relating to disclosure that you advance in your paper.
Sure. So the neem tree is one of my favorite cases, actually, when I talk about these issues. And so basically what happens here is the neem tree is native to India and countries in that region. Traditional farmers in India use the neem tree for multiple reasons, but one of them is they extract the oil from the neem tree and use it as a pesticide. So the traditional practice generally results in an oil extract that has a shelf life of 2 to 3 days. And so you really have to use it right away after you extract the oil, but it does function as a pesticide. So what happened here is a person by the name of Robert Larson, who is a timber importer based in Wisconsin. In his timber importing business, he learns of the value of the neem tree and how Indian farmers use the tree. And then based on this knowledge, he imports neem tree samples and then conducts research And then to his credit, it takes him years when he conducts the research, but ultimately he succeeds in producing a stable neem tree extract, which has a shelf life of up to 2 years, according to the patent application. And so after he was able to develop a stored stable neem tree extract, he then applied for and received a US patent right. And then in the patent application, he mentions India twice, but only in passing. And he mentions kind of the tree grows in India, and as an example, you can import this tree from India. But he really doesn't mention at all the fact that millions of Indian farmers actually use this tree as a pesticide. But in any case, he receives the patent right, and then he licenses the patent right to the chemical conglomerate, W.R. Grace. The company uses the patent to then kind of create a monopoly in the market to produce a product called Neemix, which is a pesticide, and it grosses over $60 million in global annual sales. And so when the patenting of the neem tree or the neem tree extract rather, was disclosed, and that this product is globally being used, Indian farmers and community leaders in India were outraged in what they thought is kind of what they called actually, colonization by patents, if you will, or biopiracy generally, and that this knowledge has been conserved and developed by communities in India, but the person that gets an exclusive right is kind of a researcher, if you will, or an importer in the US. And so why I use this example is to show kind of the dynamics between the different stakeholders, Indian farmers, Mr. Larsen, who actually does innovate on the traditional practice. And then at the end of it, the Indian government being pressured into challenging the patentability of this invention. And then ultimately, which I flag as being the biggest problem, which is the Indian government shutting down its kind of borders to researchers. So now, in reaction to all of this kind of biopiracy examples, so cases of biopiracy, multiple countries that used to be kind of hotspots of biodiversity and traditional knowledge are closing down. And that's exactly what happened here, where the Indian government has introduced legislations that makes it harder for researchers to use this type of knowledge.
Right. So maybe you could talk a little bit about the role of disclosure in the patent system, in particular, how it kind of played out in the neem tree oil case.
Sure. As anybody that has taken patent law can relate, there are two types of values of disclosure, but maybe stepping back a little bit. So there's a social contract in the patent system in the US, but also in other countries, where the society gives the patent applicant an exclusive right to use his or her invention in exchange for disclosing kind of background contextual information about that invention. Right? So there's this exchange that's happening between the public and the patent applicant. And so that social contract, I argue, is breached when the patent applicant kind of receives an exclusive right without necessarily disclosing all of the information about their invention. And so I see the value of disclosure, which is a kind of a key function of the patent system, is to disclose information. The first function is to teach the community, right? To say, here's the cutting edge innovation. Here's the kind of the most up-to-date information about a certain area of research. So that's the teaching function, right? That's valuable. The second function is kind of the limiting function of patent disclosure, which is where you say, here's what others have done, and I can't claim property rights over that, whatever others have done. But here's what the kind of the new thing that I've developed or invented is, and therefore I'm claiming property rights over it, right? So by disclosing, you're also limiting the scope of your right? So the metes and bounds of your patent right would be set up because of the disclosure. So this teaching and limiting function of disclosure is really key in the patent system. What happened in the neem tree example is that the applicant received an exclusive right over the kind of the neem tree extract without necessarily disclosing all of the information that's relevant for the scope and the validity of the patent right. And so my argument there is, Mr. Larsen, by withholding the existence of a traditional practice in India of using this neem tree oil as a pesticide, is getting at least a broader right than he deserves, or is getting a patent right that he might not deserve in the first place. Right. So if the information would be disclosed or would have been disclosed to the patent examiner in the ideal sense, and the patent examiner would then be able to fully examine the validity and the scope of the right, including using the traditional knowledge as a prior art.
Is there currently an obligation for inventors to disclose the use of traditional knowledge when they file a patent application? And if so, why aren't they doing it? And what consequences are there, if any, if the failure to disclose is discovered?
That's really a very key question in this research, right? And I'm glad you brought it up, Ryan. So my paper, states that, and I kind of make this point clearly in my talks as well, where arguably I think traditional knowledge is already a requirement in the U.S. patent system. And as I imagine in many other patent systems, disclosure is a key part of the patent process or the patent examination process. And so I argue that traditional knowledge is relevant and is required to be disclosed. But it's a complex matter, and my paper is trying to make the case that the requirements should be made explicit for a number of reasons, right? So let me just first address the question of whether it's actually required now or not. So the U.S. patent system says, Rule 56, and looking at a lot of the disclosure requirements, including Section 112 and other sections, what your response to the question of what am I required to disclose in the patent application, it's a very robust requirement, and the answer is anything that's materially relevant for the patent examination. It might be validity or scope of your right, you'd have to disclose, right? And it goes further than that and says, you should use the broadest interpretation available there, right? So you take each claim in the patent application, and given each claim the broadest scope possible, the question would be, would the patent examiner deem that information relevant for the validity examination or not? And if your answer is yes, then you have to disclose that information. So given how broad and robust this requirement is, I say arguably traditional knowledge is relevant. It's covered within this requirement, and that applicants should already disclose it. The America Invents Act that came into effect in 2013 is relevant here, where prior to the America Invents Act, applicants in U.S. patent applications were not required to disclose information outside of the U.S. If it's undocumented, right? So if it's documented and it's outside the U.S., you have to disclose it to the U.S. patent examiner. But if it's undocumented and outside of the U.S., it's not going to be used in the patent examination, right? So the patent applicant did not have that obligation, which it was just a unique and really kind of weird feature of the U.S. patent system, and many scholars criticized it for years. And to the credit of the U.S. legislators, they changed that to say, we do care about knowledge outside of the U.S. As being relevant for patent examination. And so now, after 2013, patent examiners do have an obligation to look at that, and patent applicants do have the obligation to disclose information outside of the U.S., even if it's not documented. While this reform is welcomed, the American Invents Act did not give patent examiners any realistic tool of accessing this traditional knowledge outside of the U.S. Right, so you can imagine a U.S. patent examiner sitting in Washington D.C. Would have an even higher kind of barrier in accessing traditional practice halfway around the corner, being practiced by communities that don't speak English, and so this lack of access of that knowledge means that even if in the books, the black letter law does require the disclosure of this information, patent examiners don't really have the realistic tool to access that information. And really, so ultimately, my question is, we should not only care about what the law says, we should care about how the law is practiced in reality. And the reality is that patent examiners, patent applicants only disclose, prior patents that are relevant for the current patent application, or scientific journals that are published prior to the patent application. That really, the patent examination process does not look at information that's not documented in this kind of scientifically organized way. And therefore, when you look at the reality, we're not using traditional knowledge, which is predominantly uncodified. It's kind of orally documented, if you will, orally transmitted from one generation to the other. And it means that because this knowledge is predominantly oral in nature, it's excluded from the patent system at all in general. And therefore, my argument is, we should really care about how the law is being practiced in reality, and we should compensate for that by introducing explicit requirements for the introduction of traditional knowledge in the patent system.
Yeah, and in your paper, you talk about the idea of information forcing rules and how they ought to structure the way we think about the disclosure requirement and penalties for failure to disclose. I was wondering if you'd talk a little bit about that, because I thought that was a really interesting concept and that you did a great job of sort of deploying it in this particular context.
Sure. Yeah, that's one of the exciting things about this paper. Was it's one of the original things that I was hoping to kind of bring to the conversation here is to tap into this literature on information forcing rules and see if that helps us here. So the information forcing rules literature was developed in other areas of in other areas of law, particularly in contract law. And basically what it says is, if you have a situation where you have two or more than two actors in a relationship, in a dealing, and one of the parties is well informed, that is, has more information, secretly held information that the other party does not have access to. And because of that secretly held information, the well-informed party behaves in the strategic way of withholding that secretly held information and blocking a socially desirable outcome, which is a dealing between the two parties, from taking place, or from kind of creating a situation where the optimal outcome would not be realized because the kind of the private gain of that party is larger than the kind of the pie, the benefit to the public. In those situations, what the information forcing rules literature says is legislators can introduce legal interventions that are meant to compel the well-informed party to disclose the secretly held information, thereby enabling the socially desirable outcome to be realized. Right? So that secretly held information would either be disclosed to the other party in that dealing, or to the general public, or to courts, or to legislators, in enabling that socially desirable outcome to be realized. So to give an example kind of outside of the patent context, a lot of employees in the US believe that their employment relationship with their employer is kind of an at-will, just cause employment, in that they believe that they would have to do something wrong for their employer to have the ground to fire them. But in reality, most employment relationships in the US are at-will, in that the employer can fire employees without any cause, and the employee can also kind of quit their job without cause. And so looking at this from the contract context, this is not a socially optimal relationship where the parties are entering into employment relationships without having full information about their relationship. And so what the information forcing rules literature says is to force the well-informed party, which is the employer in this case, to disclose the secretly held information, which is the at-will nature of the relationship, to the less informed party, which is the employee. And the way you do that is to intervene legally and say the default would be an just cause relationship in terms of employment, unless the employer explicitly tells the other party that this is an at-will relationship. So what you're doing there is you're creating a socially desirable outcome, which is an employer and employee entering into employment relationships with full information of the nature of the relationship. And so how I use that in the patent context is to say, in cases of patent applications that rely on traditional knowledge, the well-informed party is the patent applicant, and the less informed party is the patent examiner, who does not have enough information about the kind of the background and the context of the invention. And so what we can do here is to introduce a rule that says your patent application would be invalidated if you withhold your use of traditional knowledge in the research process, and that the patent examiner or other entities later on find out that you withheld information that you should have disclosed prior to the patent application or prior to the patent being granted. And really, so what we're doing here is compelling the well-informed party, which is the patent applicant, to disclose this secretly held information, which is their reliance on traditional knowledge, and thereby make it easier for patent examiners to examine the validity and the scope of the patent application. And so kind of zooming out of the technicalities of this relationship, when you look at the way we give patents or the way we analyze the validity of a patent, it's really, the relationship is it's not a leveled relationship, right? So patent examiners, one research I think said, have 18 hours per patent application to examine the validity of the patent. But when you look at the patent, the time that the patentee, the inventor, spent in developing the invention, it could take years. Usually it's more than a year or two. And so the patent applicant just has a wealth of information that the patent examiner would not be able to examine within 18 hours. And so what we're trying to do is get the information out there in the system from the least cost provider of that information, which is the party that has information about the use of traditional knowledge, for example. And my paper makes the point that although this is a problem in the patent system in general, it's really really troubling when you look at the applications that rely on traditional knowledge, because patent examiners have even harder time accessing traditional knowledge that's usually non-documented, or if it's documented in knowledge in languages that are inaccessible to U.S. patent examiners.
Interesting, yeah, and I thought it was also interesting the way that you suggest that in certain circumstances that mere invalidation wouldn't be enough to create the efficient incentive for applicants. Why is that, and what's the alternative?
Yes, I'm glad you brought that up. That's another part where I think the paper is trying to contribute and say something new about the kind of the issue. So in the literature, you see people saying, basically proposing general solutions to general problems. And what I've tried to do in this paper is kind of unpack the issues and say, really, how is this issue dealt in patent law? So what I've done is, invited people to think in terms of spectrum. So you have a spectrum where, on one side, on the left-hand side, when you're asking the question of how much disclosure, not how much disclosure, what should trigger the requirement to disclose, you're asking the question of, how much reliance on traditional knowledge, how much use of traditional knowledge should there be for us to require disclosure? What should be the trigger for disclosure? And so on the left-hand side, I kind of group relationships between the researcher and traditional knowledge in terms of inspiration. So the researcher is inspired by traditional knowledge, but really they don't use traditional knowledge after that. So they basically are inspired by how communities do things, and then they go off and do research in other areas. So in those cases, I say, disclosure should not exist, and failure to disclose kind of inspirations should not result in any penalty. But you can imagine an even higher level of reliance on traditional knowledge where, if the researcher had not worked with the source community and had access to traditional knowledge, either the invention would not have been developed in the first place, or that the development of the invention would have taken significantly more time or resources. And so in those instances, I argue we should require disclosure, and failure to disclose should amount to patent invalidity. Right? And I argue that the neem tree example that I talked about earlier does fall within this grouping of what I call substantial reliance. So in those cases, I think there should be disclosure and the penalty should be patent invalidity. But then you have these cases in which researchers, rely on traditional knowledge to a higher degree, in that they're not really innovating on the traditional practice, but they're just trying to claim exclusive rights on the traditional practice and hope that the examiner does not find out that there's a traditional practice halfway around the world that would invalidate their patent application. So in those instances, introducing one, I say there should be disclosure, obviously, but if disclosure is made, you can imagine that the patent applicant is worried that their patent will be invalidated easily because, in the face of the traditional practice being disclosed, the examiner would say, you have not invented anything here, and therefore you do not deserve to get a patent right. And so for those types of applicants, we need to introduce a penalty that's harsher, if you will, or at a higher level than patent invalidity, to encourage them to disclose that information in the face of the risk of patent invalidity. And so in those instances, I suggest that legislators introduce fines or disgorgement of profits as harsher penalties to encourage those types of applications.
So your proposal strikes me as really like a clever and elegant solution to a problem particularly in relation to information disclosure and the efficiency of the patent system. What about implementation? I mean, do we need legislation like specifying that this is how the patent office should treat disclosure, or are there ways that the patent office could do that on an administrative level?
I do believe that the best ideal way to address this issue is kind of amending the U.S. Patent Act to say that traditional knowledge is explicitly required to be disclosed in the patent application. And the reason for that is that in the paper I talk about this troubling kind of trend where source communities or countries that used to be sources of information and genetic resources, biodiversity, are closing down. And so the U.S. patent system is thought to be part of the problem there, to the extent that applicants in the U.S. patent system are gaining exclusive rights on traditional knowledge that source communities believe is unfair. And so this bold move of reforming the U.S. patent system by introducing this explicit requirement that traditional knowledge be disclosed in the U.S. Patent Act would give a strong signal to communities around the world to say, this feature of the U.S. patent system that you think is problematic has now addressed that situation. And so it would help in kind of undoing this protectionist trend and convincing source communities to open up their markets to researchers from the US, but also from other countries. And so, one of the reasons I think that the requirements should be explicitly disclosed in the US Patent Act is that it just sends the strong signal to other countries and communities that other types of reforms might not do. And so that's one. But I follow that argument with kind of an alternative argument of saying, I do realize that the kind of the political economy of the situation means that there are vested interests. For example, pharmaceutical lobbying interest would make the case that introduction or reform of the Patent Act is unjustified, and therefore, realistically speaking, the odds seem to be stacked against advocates of change in terms of changing the Patent Act. And so the second argument I make is, really, when you look at the current disclosure requirement, because it's robust and broad, traditional knowledge is arguably already required. And so the U.S. Patent Office does have a power to explain, the rules in its guideline, the Manual of Patent Examination document. And that document is kind of updated frequently, and doesn't require consultation with community members and stakeholders. And really what the USPTO there is doing is to basically explain what's already required. And I think that seems to be the case here, to basically say, after the American Invents Act, undocumented knowledge outside of the US is part of the patent examination process. And so to explicitly say patent applicants that rely on traditional knowledge currently do have an obligation to disclose traditional knowledge would be sufficient. And so you see other examples of the U.S. Patent Office saying this, right? So it follows this traditional, this broader requirement of disclosure with specific explicit requirements of disclosure. For example, it says if the researcher has used commercial databases, then the researcher has to disclose that fact to the U.S. Patent Office and tell the patent examiner that they've relied on a commercial database and give the examiner access to that commercial database. And so when I think of the rationale behind the specific disclosure requirement following this general robust disclosure requirement, it is to make the case that we know you have this general obligation, but in case you're kind of not clear about the specific requirements of disclosure, we're making sure that you know that you have that obligation. And I think when you see the dynamics between researchers and source communities and patent examiners in the traditional knowledge context, that's really what's happening. Is the researcher saying, I did not know traditional knowledge needed to be disclosed because it's undocumented, it's challenging to disclose. And so in case you're not aware, we're making it super clear that you have to disclose traditional knowledge.
That makes a lot of sense. Yeah, I mean, that makes sense to me too. So, Aman, in closing, I was wondering if we could take a step back and kind of talk just briefly about how your paper fits into the scholarship on biopiracy more generally, because you sort of mentioned in the paper, and it kind of is consistent with my sense of the literature, that the bulk of the writing in the area kind of largely comes at the problem from a sort of moral rights perspective, looking at sort of the how different countries deserve to be able to be treated and what they deserve to be able to claim, and you characterize your paper as coming at the question from a kind of more welfarist perspective, and I was wondering if you could kind of talk a little bit about why you thought that was an important move, and also maybe whether the proposal that you're making will also result in some higher degree of equitable redistribution of the positive externalities associated with innovation.
Yes. So I actually think that's one of the main contributions that I hope my scholarship generally brings to the table, which is, when people look at the relationship between multinational corporations that have resources, financial resources, human resource capital, and on the one hand, on the other hand, source communities, indigenous peoples, local communities, it's really easy to see the equity issues that arise there, right? Considering the history of these parties, considering the power dynamics between those two parties, it's easy to see that there's a huge kind of equity issue there, a distributive justice issue there. And so I do agree with a lot of the scholarship out there trying to make the point that equity does kind of signal that we should do something different in this relationship. And so I do buy into that scholarship, but when I see the scholarship, I think it's missing this welfarist angle, because really it's not because companies need to be nice to source communities that they have to protect their knowledge, or that the law should protect their knowledge. In addition to it being equitable, it being fair to recognize the knowledge of source communities, it's also efficient and useful for innovation policy to actually make sure that the original sources of information are encouraged to conserve and disclose that knowledge. Right? So that's the point that I try to make here, is to say, it's not just because we're trying to be nice to source communities. It's also in the self-interested way, because it's relevant for innovation in general, that we have to recognize the value of traditional knowledge and encourage the people that conserve it and have been conserving it for centuries to invest in the conservation work that they do, but also to disclose it to outsiders, right? So to undo this protectionist trend, we do, I think, need to protect traditional knowledge. And so some of my other papers do make that point, that, the kind of the welfarist kind of argument or theory that I develop here is supposed to be complementary to the equity and distributive justice rationales that have been adopted by other scholars. And to respond to your question of, why is this needed? the discussions around biodiversity conservation, the protection of traditional knowledge, have been happening since the 1990s. So mid 1990s, you have the 1994 Convention on Biodiversity that recognizes the right of communities over their traditional knowledge and genetic resources. But that conversation really, did not fruitfully result in any realistic international legal framework or practice of recognizing the right of communities and sharing profits with them in exchange for more access to traditional knowledge and genetic resources. Right. So that was the intention, but really that conversation did not progress. And I think one of the reasons that a conversation did not result in a fruitful scenario is because I think advocates of traditional protection have only used equity and distributive justice. I shouldn't say only, because there are a number of scholars out there that use the welfareist angle. But really, when you look at the scholarship, it's just screaming for kind of this other argument to be made. So, for example, if you look at the World Intellectual Property Organization, there's a committee of the organization that has been talking about a convention on traditional knowledge for more than 15 years. But that conversation has not kind of resulted in a kind of practically applicable convention, in part because I think it doesn't appeal to a certain stakeholder, which is kind of the industry, if you will, the firms or countries that respond to innovators, if you will, developed countries that are affected by the lobbying power of innovators and industries. Have not bought into this framework because the case has not been made that it's not just because we're trying to be nice to source communities. It also makes sense in terms of purely economic terms to protect traditional knowledge and make sure that the innovation relationship is more collaborative as opposed to a relationship filled with mistrust, which currently is the case.
Great. Well, thanks so much, Aman. It's been a real pleasure talking to you about your paper today.
Thanks for having me, Brian. It's been fun.
I'm Elm Hill Bill, I'm big and strong. I chop down elm trees all day long, and each of these I place with a smack on an Elm Hill quality all-meat pack. The greatest wieners, yes sirree, cause wieners are our specialty. They taste so fine, the flavor's true, vacuum packed to stay fresh for you. Baked and smoked and very lean, ham's the best you've ever seen, filled with Elm Hill tasty light, a treat to make your day just right. Tater dogs and barbecue, 54 meats all for you. So when you're at your grocery and you see there the lone elm tree, you'll know the package that it mounts is Elm Hill meats where quality counts.